Okay, the next section I wanted to just touch on here is the landlord's remedies for alterations. The tribunal may, on application by a landlord, make the following orders. An order prohibiting the tenant from removing a fixture. An order that the tenant compensate the landlord for the cost of rectifying work done on or behalf of the tenant on the residential premises. So there's a little bit of joy in that, not a lot, but there's a little bit. The tribunal may make an order under subsection 1B only if it is satisfied that the work was not done to a satisfactory standard, no definition of satisfactory standard, and the work, if not rectified, is likely to adversely affect the landlord's ability to let the premises to other tenants. So there's a little bit of movement in that, what people put into property and the compensation that can flow from it. And there's a final section there that they can order the work to be done and the tenant will have to pay for it. But again, there is no requirement in this section that says you have to use qualified people. And I think it's a major mistake. I mean, the days of the odd job man are really numbered as far as I'm concerned, because the people who use unqualified people the agents that do that run themselves into potential risk. Why would you risk being sued because you have somebody who can do it at a cut rate? It just doesn't sound to me like good business practice. So there you go. The next one I want to talk to and this is one that Tim referred to earlier on, and we're talking about section 74 of the Act. And it's to do with changes to the situation with landlord and tenant. The first section I want to deal with is the transfer of tenancy or subletting by the tenant. Now, it starts with section 1, which I find quite interesting, but I think it's also the one that's going to make in your minds up to, in future, only having one tenant in a property. A tenant may transfer the tenancy under a residential tenancy agreement to another person or sublet the premises to another person if the landlord gives written consent to the transfer or subletting. Okay? Now, obviously the landlord can't charge for giving that consent. So if you've got a situation where you've got a single tenancy and the tenant wants to go, that's relatively easy to deal with. But once you get multiples involved, that's when you start having problems. And I think, as Tim alluded to earlier today, most of us will start moving down that track that with every tenancy you'll have one tenant. You can have other occupants because it's an easier way of dealing with other occupants. But as far as the changing of a tenancy and subletting, it's got to be done with the written consent of the landlord. Okay. There's no requirement for reasonable refusal for the whole transfer of a subletting. The landlord may withhold consent to a transfer or subletting relating to the whole tenancy or the residential premises, whether or not it is reasonable to do so. So the landlord can refuse that. All right? But when you run into the next section, we're talking about the landlord must not unreasonably withhold consent to transfer of a tenancy or a subletting of premises if the transfer results in only one or more of it, or more tenants in addition to the original tenant. So if you've got a situation where you've got two tenants and one of them wants to go and they want to put in two to replace them, the landlord can't unreasonably withhold consent on that. But if both tenants, or one tenant or both tenants want to leave and there's no subdivision of it, then the landlord can actually deal with that as a separate item altogether. Okay.
Can I just ask a question again? Now, Now, with the lease where you actually stipulate the amount of persons to occupy the premises, now, has the tenant then got the right to let one person go and bring in the additional 2 people if they exceed the restriction on the lease?
There is a restriction in the legislation in relation to the number of parties that can occupy. If you've set a limit, then there are 2 sections here. The landlord is entitled to withhold consent if the number of proposed occupants is more than the number permitted under the Residential Tenancies Agreement, okay, or any applicable approval under the environmental and planning provisions, 1979.
This is a very important issue, and that's the reason I stopped your earlier question. But I guess we fought this about being able to, with the landlord losing control of essentially who was going to occupy their premises, and we had some wins, but we didn't have the big one. So in other words, the legislation as it's currently drafted, and I invite you to correct me, Tim, but as I understand it, if there is more than one tenant in there, that you can end up with a situation where there is, you could end up with another tenant in there that you wouldn't have selected and wouldn't want in there, although you're deemed to be unreasonable to have denied them access to the property, denied them access to be a tenant. So the workaround, and this is some of the work that's been done internally, is that we believe by having just one person on the lease, a single tenant, that you avoid that problem. So from this point forward, I guess it's a decision for everybody in the room, and I invite your comments, Tim, but we're of the view maybe you should just have one tenant.
And how many will cover with that? If you put one, how many people can be?
Well, that's what you allow. You can allow other occupants, but they don't come under the actual tenancy itself.
Because I was of the impression that just that if you lease a 3-bedroom home, you're allowed for more than one person to live there.
That's right. So there's a difference between occupants and tenants.
Yep.
So you've got one tenant, but a number of occupants. Yeah. Okay. So I mean, the obvious question, we got this yesterday, the husband and wife. Well, clearly, then who do you select? Well, you select whichever party's earning the most money would be your tenant. Sure. But if you have more than 2 tenants in there, you create the problem where you can end up with a situation where you would potentially have a tenant that you wouldn't have selected. So that's a workaround, and that's why we're going through the legislation now. It's an example of it.
Doesn't the written consent override that? You still require the written consent of the landlord, don't you?
No, that's where we're talking about being unreasonable. So
the tenant goes and says that goes to the tribunal and says the landlord's decision to refuse is unreasonable. Then this whole section comes into play.
You can have bonds in 3 names, but the lease in one. Because how do they have protection on their bonds that own shared tenancies?
No. They don't. And if you've got the situation, if the head tenant gets up and leaves other people there without their landlord's consent, what we used to do is go and lock them out. But you can't now. You've got to give them 14 days' notice to go. Hey? What's that?
It's been a long time since you're
Yeah, but unauthorised occupant, you can lock them out. Yeah. Of course you can. There's no tenancy rights for an occupant.
So,
and there's still not.
None of this is perfect. As I was saying, if you go into it with your eyes open, if you have more than 2 tenants on the lease, or more than 1 tenant, 2 tenants or greater, then that's the problem you face. The gentleman's point over there is well made, but you need to go with your eyes open. So you may end up with a situation where you have a tenant that has been proposed to you, you think is not appropriate, you wouldn't have accepted them on day 1, but it'll end up in the tribunal and it'll be a decision as to whether you're being unreasonable or not. If you want to avoid that, that's a workaround, not perfect.